So today's video is about negotiating a fair severance package. So first of all, I think it's important to share information. I had a bullet point on this in my previous video, and I actually skipped over it by mistake. So specifically, if a lot of people are let go that are senior employees, that can lead to definitely a lawsuit for discrimination. So if multiple people were let go in the same job role, start a group message board, share wages, age, gender, and severance offers. A lot of us feel that that's personal information. In California, you're definitely allowed to share wage information, especially if you don't work there anymore. So I think it's important to see if there are any patterns that were discriminatory. And then try to get the employees that weren't terminated to share information, or at least, to comment and saying, yeah, we're not making anywhere near that. Help to show that only senior level people were let go. You want to share grievances as well. A lot of times we're not talking about these when we're working there, trying to keep them private. And once you let go, on the same side, it makes more sense to share grievances, see if there's any patterns there. Also, while you're all hanging out on this group message board, share job leads, request recommendations from each other on LinkedIn. So people that sign the severance agreement, so in my previous videos I'm saying don't sign it yet, but if people have signed it because they didn't watch my video, they might not be able to discuss their severance offer or disparage the employer, but they should still be able to share their wage information. So because eventually we're trying to sign a severance agreement that's probably going to have a non-disparage agreement, now's the time to leave that Glassdoor review before you get a non-disparagement agreement in place. So unemployment insurance, I mentioned before, you should apply right away. Don't wait till your severance is over. There's still, in California at least, there's a 1 week waiting period before you can start collecting. So if you leave on Friday, the whole next week, you won't be able to get unemployment, but the week after that, you will. So some important things to note is the severance supplements UI, so it should not offset any weekly claims, but the employer might disagree when they receive notice from the UIA. So, and unfortunately this happens a lot. The UI will say, well, I was offering them 2 weeks severance, and that came as, a regular payroll payment that they made. So they're going to disagree on when your actual last day was, mostly because they don't know the law. So you might have to fight that with them, unfortunately. But just be assured that the law's on your side, that severance is meant to supplement UI, is not offset it. So 401k distributions and early retirement pensions do offset UI. So if you realize that you're going to be short on money and decide to take some distributions from your 401k, basically what you're going to do is divide that money that you distributed from your weekly payment, and that's how many weeks it's going to offset. Pensions are basically going to offset because it's a recurring payment. It's going to continue to offset your unemployment benefits. So your employer might also try and say that you were let go due to misconduct. So it's usually not the case, even if they believe it's true. It's there's a lot of things that are not considered misconduct. So to be misconduct, an employee must have engaged in conduct evincing such willful or wanton disregard of an employer's interests as is found in deliberate violations or disregard of standards of behavior which the employer has the right to expect of his employee, or in carelessness of negligence of such degree or recurrence as to manifest equal culpability, but not mere inefficiency, unsatisfactory conduct, and inadvertencies or ordinary negligence. So, if you're having a hard time at work, it's best to underperform than to perform in a way that's going to hurt your employer's interests. So, but as long as you're not intentionally, working against their interests, and as long as you're not your behavior isn't repetitively crossing the line of what they can expect, you should be good to go. So some common decisions on what doesn't qualify as misconduct in case law. So leaving to accompany a spouse, fiance, or parent of your child to go to another state is not considered misconduct. You're not considered to be quitting. You're definitely eligible for unemployment. There are some limitations here, like it can't just be a significant other. You have to have a child or a pending child or a pending marriage. So if you want to make it legit, right, just propose. Then you can move out of state and won't be considered quitting. You can get unemployment benefits. So if you get a substantial reduction in earnings, basically the threshold there is 25%, then you can quit and still get unemployment benefits. If employer demands something that hadn't been established as expected or required condition of employment. One interesting example from case law is that two employees weren't getting along, and the boss said, "You have to start communicating with this other employer. I'm gonna have to let you go." Well, the condition of the person's employment was not having to talk to this other person. So, see ya. Wouldn't want to be ya, and I'm still gonna get unemployment. So if you're demoted and asked to train your replacement, so your employer might think that that's okay, but case law has determined that a reasonable person should not be required to do that, to train the replacement after they've been demoted. So failure to sign a disciplinary notice to prevent admitting guilt is okay. If they're trying to counsel you out, you don't have to sign the papers. So leaving for your health or the health of others. So if it's if there's a smoky environment and you believe it's not healthy for you, you're welcome to quit. If something you're doing you believe is risking the health of others, then you're welcome to quit too. And then any single heated exchange would be considered a mistake or error in judgment. And then lots of other one-offs could be considered a mistake or error in judgment and not misconduct. And then finally, the burden is on the employer, so don't be afraid to appeal it. So let's talk about Cobra, which is basically continuation of health coverage benefits. When you leave your job, your employer was providing you health benefits. Is required to offer you the chance to continue those coverage. But usually you have to pay the full amount that they were paying as part of your benefits package. So while you've waited to sign severance, if your severance included your employer paying for Cobra continuation, because that's sometimes something that they offer, like we're going to give you 2 weeks pay, and then we'll pay for your Cobra coverage for 2 months. So typically, because you're not an employer anymore, they're not allowed to just keep you on their group, but they are allowed to reimburse you for your Cobra, or preferably pay directly. So if you've waited to sign your severance, I mean, they're probably going to just go ahead and do that while they wait for you to sign, because it's not something that they can wait to do. So they'll likely perform that part of the severance agreement, even though you haven't signed it yet. So whether or not they offer to pay for it, when they offer you the Cobra continuation of coverage, don't turn it down. You'll have if you don't turn it down, you'll basically then have 30 days to pay for that to kick in. But I say don't pay it unless you need to go to the doctor that month and the bill's even more than the monthly premium. So you're basically getting kind of like this emergency disaster coverage, right? So if like the premium's probably gonna be like $400, so if you need to go to the ER and it's gonna cost a lot to fix you, and then when you get home from the ER, you probably want to go ahead and make that Cobra payment. Otherwise, if it's gonna be less, just pay out of pocket. There's no reason to pay the Cobra. But that should cover you the month until your subsidized coverage through the marketplace kicks in. So I said don't pay it unless you need to go to the doctor that month, and the bills would be more than the monthly premium. So loss of employer-sponsored coverage or loss of employer-contributed Cobra coverage is a qualifying life event. So you're probably aware of this, but you can usually only change your health insurance through your employer once a year, and you normally can't sign up through the health insurance marketplace through the Fed unless you have a qualifying life event. Well, the loss of your employer-sponsored coverage, or if they're paying for your Cobra, once they stop paying for the Cobra, that's a QLE. So now you can go to Covered California and use the QLE to purchase subsidized coverage. So if you're only making your unemployment benefits, you're going to end up getting regular health insurance, coverage that qualifies under Obamacare. So it's the good stuff for a pretty low amount. Right. So let's say you sent the letter requesting your personal record, and you've applied for uninsurance, you're doing all the other stuff I said. So 30 days have passed, and you haven't received your personal record. More than likely, this is going to happen. Your employer is not going to send you the personal record, especially including emails and messages that discuss your performance and why you're terminated and any grievances they have against you. So it's been 30 days. Any severance offer probably has expired, even if you are over 40 and your 21 days that you had, is obviously less than 30 days. But it's not a big deal because you can use a claim for intentional interference with prospective economic advantage to get that severance package back on the table if needed. So if they haven't violated labor code before, they have now by not sending your personnel record. So now we're going to add up and figure out how much we're going to ask for. Usually it's going to be a multiplier of what they offered you as a severance package. So it's going to be 2, 3, or more of the original offer. So 1 hour wages for each meal period missed from my previous video. Refer back to that if you don't know what I'm talking about. up to 30 days of wages for each day you had to wait for your final paycheck with earned PTO on it. So if you work there a year, right, and that's I forget how many work days there are typically in a year, divided by 8, right? So that if you work there for a year, they're gonna owe you a few weeks of pay just for that, and then if they didn't pay you, give you your paycheck on time, that's 4 more weeks, right? So you see how this is starting to multiply, especially if they only offered you 2 weeks. Any earned PTO not paid, including unlimited PTO policies, right? They still owe you that, so that's some more that they owe you. They didn't provide your wage statements after 21 days. That's a $750 penalty that you're able to collect, as well as a $750 penalty for not providing personnel records within 30 days. You're pretty much guaranteed that. I don't know how many weeks of pay that might be for you, or days. We'll tack that on. So original severance offer if expired. So I want to add that, the original severance offer, to everything we're adding up. And then any other promises and interest. So I mentioned before, one employer once offered to pay for a medical procedure for their employee, and they still had to pay it after they left. And then, of course, interest on those monies. Right, so when it comes down to negotiating the settlement agreement, you want to call up HR at least a business day before any existing severance offer expires. So if we kind of go back here, right, so the previous slide was 30 days later. Well, make sure you call them before the previous severance package offer expires, and let them know you've not received your personnel records, and ask them if they would like to make a new offer. Right, you don't want a counter offer because when it comes to offers and counter offers, you're pretty much canceling out any offer when you make a counter offer. And leaving a voicemail is okay. It might even be better at times if you don't like talking on the phone. If you're anxious about doing this, you might just ask for the HR person's voicemail. Then once you mention the labor code violations, the HR person is likely to require that they talk to your attorney. I don't know why this happens. It's just people are ignorant. They say like, well, if you're threatening me with a lawsuit, then I can't talk to you. I can only talk to your attorney. It's not true. There's no statute that says that. But it's fine, right? Say you're hopefully dealing with your Legal Shield attorney. You talk to your Legal Shield attorney about your case, and they'll be up to speed on this. You might have even had them send one letter or maybe one phone call already to try and negotiate the severance offer package up. Well, let them know that they're welcome to go attorney to attorney, but it costs you money. So ask them to pay for your Legal Shield attorney. And that's not uncommon, happens a lot, that they will go ahead and do that. So things to ask for in the settlement agreement, make sure you get a mutual non-disparagement, right? Not just where you're not going to talk bad about the company, but it needs to be where the company won't talk bad about you. And they probably already have internally have them agree on to an internal message, and they're not allowed to go break that. And if you end up suing them, you can always subpoena that and then get injunctive relief for your personal records. So if anything is an email or in Slack messages or Teams messages. So that adds more weight to them selling. So make sure that the payments supplement UI. So the California law, unfortunately, for all settlements, whether damages or not, unless the damages are for medical or physical damages to you, they have to withhold taxes. So if you settle for 10 grand, right, expect them to withhold taxes and take out FICA and even the California disability insurance out of that. But make sure that and they're going to report it as wages, which is fine, but make sure that the wage period is prior to your termination date, because this just happens so often where they're not going to do that, and that's going to mess up your unemployment benefits. And even if they fail to do that, you want to make sure it's in the agreement that they will do that, so that instead of having to deal with the unemployment insurance company, which is sometimes impossible to get a hold of them to correct issues like that, that you can just go ahead and if you end up missing weeks of unemployment benefits because they reported money that offsets unemployment benefits, then you can get that money from your ex-employer instead of having to fix the errors in the unemployment insurance stuff. Request a letter of recommendation from your supervisor. In California, any non-compete is illegal. You want a mutual waiver of past claims, right? You're not just agreeing not to sue them for past claims, but if you accidentally, if you're a coder, introduced a bug in some code and it causes damage, you don't want them coming after you for that either. So make sure the waiver of past claims is mutual. Don't agree to a waiver of future claims. That doesn't even make sense here because if they end up disparaging you after you sign this agreement, then you're going to have to sue them. Make sure it awards attorney's fees to the prevailing party. It adds some strength there, and make sure that they're careful not to disparage you. Ask for placement services. One thing about placement services you should be aware of is outplacement services is not the same as placement services. So if they offer outplacement services, that's just some person who claims to be an expert at resumes, helping you update your resume, maybe practice some interviewing. They're not actually helping you find another job. So if they offer outplacement services, say no, you really want some placement services. You want someone who's actually working every day to try and find positions that would be good for you, and possibly have a network of places that they can place you with as well. So make sure venue is in the agreement, especially if you are moving out of state as a result of your job loss. Right? You could say this contract is under California law, but that either party can bring suit wherever they reside. All right, so if you're still not able to negotiate a fair severance package, it's time to file suit. So make sure to remind them of the increased cost to settle after filing a complaint in court. Ask them if after you mail your intent to sue to the registered agent for service of process, whether they would like you to email a copy of the letter to anyone, perhaps the CEO. So this actually works really well. CEOs get pissed when the HR can't resolve things without you bringing suit. But in my next video, we'll go ahead and type up our intent to sue letter, and then the video after that, we'll type up our complaint to file in court if they still don't want to be reasonable. Thanks for watching my video. Go ahead and subscribe if you are a subscriber, and comment. I will answer them in a response video next month. Thank you. Bye.